Welcome, everyone. This is the Eviction Expungement CLE for volunteers, Legal Aid Services of Oregon. I'm pleased to introduce our presenter today. Our presenter is Diane Nguyen, a staff attorney at Legal Aid Services of Oregon's Portland Regional Office. Diane graduated from Lewis and Clark Law School in 2018 and clerked with the Oregon Supreme Court and Oregon Court of Appeals before joining the Portland Regional Office. At the Portland Regional Office, Diane practices poverty law, primarily handling tenant side housing work and co-counseling on state appeals. So without further ado, Diane, take it away.
Thank you, Shelby. I'm going to share screen here. If you can confirm that that is showing for everyone. All right, All right, thanks for joining us today, folks. As you can see, we are covering the Oregon Eviction Expungement, which is codified as ORS 105.163. Before we get into the substantive law, I'm sure people are familiar with what expungement is, but just to kind of go over what that is in the context of evictions, and as well as what are the reasons why eviction expungement is such a powerful tool for tenants. I want to discuss here are the pros of the eviction expungement process. One, the eviction expungement erases the eviction record completely. And what that is in the language of law is the judgment then gets set aside and the official records are sealed. What that means is a landlord or a prospective landlord or a tenant screening or background screening company that they may hire during the application process, when they look up the tenant's name, for example, in court records in OECI, they would not be able to find a record at all and see it. So although the law prohibits a landlord from considering certain types of records, and as we'll see in the preceding slides, some of the records they're not supposed to consider are the very records that are eligible for expungement. As a practical matter, this language about landlords not being able to consider a record, I'm not really sure it has any teeth in real life, because how is a landlord, how do we really determine whether they're considering something? And it's fairly easy, as we've seen doing tenant work, is landlords can come up with pretextual reasons for denying an application. So removing a record completely and making it not available and not viewable in the court record system is a way to just really remove the temptation for a landlord to even come up with pretextual reasons to deny a tenant. And a tenant can also, as a practical matter, they can answer no, and that would be a truthful answer and not providing false information to a landlord when they are applying for a rental, which many prospective landlords ask in their application materials whether or not a tenant has been evicted in the past. And with the record expunged and erased, the tenant can truthfully answer no. And then, as we'll see, also this process is free by statute, and it is quite easy of a process, so much so that you will likely find me very dispensable as we get to the other slides and wondering why I'm explaining something that's fairly self-explanatory. So those are the pros of eviction expungement. This slide, I have a healthy dose of self-skepticism about myself, so I held a slide for any cons that people may be able to think of. I myself don't see any cons to a process that removes huge barriers to housing for tenants, that is both free and easy. And if we can kind of go back to the previous slide and talk a little more about the practical effects for tenants. Many tenants who have a eviction filing against them, regardless of the outcome, once a landlord pulls up a record in OECI, they're not necessarily looking through every record to see what the outcome is. All they see is an eviction record, and based on that alone, that could be grounds for why, impermissible grounds, but it could be grounds for why a landlord denies an applicant's rental application. In cases, for example, even if a tenant wins the case or they reach an agreement, or the facts and the allegations in the FED, the eviction complaint, are untruthful or inaccurate or misleading, those are not things that a tenant could necessarily, they might not have necessarily challenged, and that information makes it into the court record. And even when they do, that's not necessarily something that when landlords, prospective landlords, or their screening companies are looking into the tenant's rental history, that they're seeing the information. So lots of tenants get denied housing based simply on the eviction filing itself, and that traps individuals and families in a cycle of poverty, because housing instability, there's well documented information that links housing instability to other detrimental outcomes for folks in the arenas of, for example, education, employment, and health. And folks who are experiencing housing instability are more likely to become entangled in the criminal legal system. And then, as with many of these detrimental effects, what we see is also disproportionate impact on the BIPOC individuals and communities. So the expunging a record helps to mitigate all of these these housing barriers that exist for tenants. So again, the positives, I'm not sure there are any cons. And then moving from the why it's a powerful and necessary, important tool, we'll get into now the substantive law. As a background, this is sort of the overview of how we're going to cover the law today on Oregon eviction expungement. We'll start with the Senate Bill 873, which was passed in 2019, and it took effect in January 1st of 2020. That's the Oregon eviction expungement law that is now codified with ORS 105.163. In 2021, the Oregon legislature passed Senate Bill 282, which was during the height of the COVID-19 pandemic, and there were COVID-19, we call them COVID-19 tenant protections that were included as part of that bill, that most of which have already expired, but there was an amendment specifically related to Oregon eviction expungement that is still in effect and is the current law. That will expire, or will sunset in January 2nd of 2028, and we'll talk about what that change is in the law before and what it'll be after that provision sunsets. And then the last thing is House Bill 2001, which passed just last week on March 29th. 2023. And in that bill, there is language that provides for the automatic expungement of certain types of evictions. So those are the sort of three areas of the law that we're going to be covering here. All right, so this is the state of the law after following the Senate Bill 873 without the addition of Senate Bill 282. What the types of evictions that are eligible for expungement are judgments of restitution that is at least 5 years old and the tenant has paid any money that they owe under that judgment. Judgment of restitution, in effect, is a judgment in which the landlord and tenant went to trial and the court determined that the landlord has the right to restitution to regain possession of the premises. Essentially, a case in which the tenant has lost. So if they lost at least 5 years ago, and if they were ordered to pay any money in that judgment and they have paid it off, that record now becomes eligible for expungement. Second type of judgments or eviction records that are eligible for expungement are those that were reached by stipulation, which is a settlement agreement that was made between the landlord and tenant with court approval. If the tenant has complied with all the terms of the agreement, and including if there were any terms that require payment of money, they've satisfied all that, then the record becomes immediately eligible for expungement. Common terms that we see in these sort of stipulated agreements are, for example, requirements for a tenant to move out by a certain date, or for a tenant to follow a certain rental or money payment plan. And once they've satisfied that, that is sufficient for the tenant to be able to request the expungement of the record with the court. And third are the judgments that are in tenant's favor. So that includes a judgment where maybe pre-trial, the tenant was able to get the case dismissed, or post-trial, the tenant takes the landlord to court and fights him at trial, and the court determines that the tenant is entitled to possession of the premises. So if they win the trial, the judgment is in their favor and they can get that record, that filing expunged. And that also includes judgments of dismissals, which are considered judgments in the tenant's favor. And dismissal also including, for example, if at first appearance, tenant shows up, landlord does not show up, by statute, the court is supposed to dismiss that case, and that is considered one that's in the tenant's favor, even though it was not determined on the merits. All right. Next slide here is where we add in the extra language that's added by SB 282. As you can see, the first three types of judgments that are or eviction records are eligible for expungement remain the same, and there's an addition regarding SB 282 as opposed to any changes to the existing types of records that are eligible. But the next new addition here is that if the eviction, the basis for it arose on or after April 1st, 2020, and before March 1st, 2022, and the tenant has paid any money owed, then that record becomes eligible for expungement. And so that time period, April 1st, 2020 to March 1st, 2022, is the time period that we consider in Oregon the eviction moratorium period. So in the eviction moratorium due to COVID-19. So anything during that time period, most of the concerns with that time period, I think, were related to non-payment of rent. But the thing to note that's important with the SB 282 addition here is if an eviction arose during that time period, regardless whether or not it was an eviction for non-payment of rent, or if it was an eviction alleging, for example, the tenant had violated other tenant obligations or landlord-tenant law, for example, by assaulting a neighbor, even something like that, which we call a for-cause termination or termination with reason, those are still equally eligible for expungement. And note there is that SB 282, so that provision that adds that additional grounds for expungement that expires on January 1st, 2028. So taking effect on January 2nd, 2028 is a reversion to the criteria that we covered in the prior slides. And also note that the ORS citations I have on this slide reflects the current state of the law with SB 282 in effect. And once it reverts back, there'll be different citations here. Okay. So the next slide here is about the expungement process. Now that you have determined whether or not a record is eligible for expungement based on the eligibility criteria that we just covered in the prior slides, the steps are very simple, laid out here. And then in the next slide, we have the picture of what the motion looks like. Some screenshots of what the motion looks like. First step, tenant files this motion to set aside the residential eviction judgment in the county where the eviction had happened. There is a state form that's provided by OJD that can be used for that. In the next slide, we'll show that. And then by statute, there's no filing fee. The one thing to note about this is if the eviction case involved multiple tenants, for example, if I was a tenant, I rented here the landlord, and I also had a roommate, and the landlord, we're on the same lease here, so the landlord tries to evict the both of us, and then when they file the eviction case, they name both of us as defendants separately. Both of us as defendants. If I file the motion to have this judgment set aside, it would only affect me and it would not erase the record automatically for my co-tenant and co-defendant. So each tenant in the eviction case should be filing their own expungement request. Once they have filled out and filed that motion with the court, they would need to serve a copy on the landlord in the eviction case. And within 30 days of service of that motion, the landlord can file a written objection. If the landlord objects, the court needs to set a hearing, and then they will decide at the hearing whether or not the tenant meets those eligibility. So often what might happen, I shouldn't say often, but what could happen is a landlord would say that the tenant actually has not met all of the, complied with all the terms of the stipulated agreement, or perhaps there is outstanding, allegedly outstanding money order that needs to be satisfied by the tenant before it can be erased. So I'm seeing some questions here. Shelby, do you usually handle those at the end?
I can ask them
Yes.
right now. So I'll just state it for the group. Katie asks, if a married couple was evicted, does each individual need to file a motion to set aside?
Yes, well, if they are both named as defendants in the FED on the complaint for the eviction case, they should both file separately. Because the marriage itself is not what determines whether or not a tenant might be a defendant in an action for possession, right? If I'm married, but I live separately from my partner, or if I'm married and one person's on the lease and the landlord might not know the other person is also living there and have not actually named that person on the lease, that doesn't necessarily define who is going to be the person that's affected by a judgment of restitution or a judgment of stipulation or dismissal here.
Okay. And does service on the landlord need to be personal service? Does it need to be by process server?
It does not need to be by personal service or by process, no.
So would you just say mail service?
Mail service is sufficient, yes. And we can cover a little more of that in the next slide as well when I have the screenshots of the forms that are used. But just to finish out this one, right? So the landlord files a written objection. For example, they say that there has been lack of compliance with all of the terms or failure by the tenant to satisfy completely the money judgment. Then the landlord will have a hearing to determine whether or not the tenant has satisfied the criteria for eligibility for expungement. And if the landlord does not object, then the court will rule on the face, based on the record before it, whether or not the record is expungible. All right. So this is the screenshots that I kept on alluding to. This form, the links of which are in the bottom right there, are available on OJD's website. And even on that first link meant, I guess look at a URL says 2020-0101. This is the form that was pulled from it, which you can see is from updated February 2022. Both links are to the same form when I tested them, but they were in different places, so I provided both links here. The 2022 update here, the main change, and I don't know if you're able to see my mouse when I move it over here, but under the declaration, if you look at the under declaration on page 102, the very bottom box there, judgment was based on claims that arose on or after April 1st, 2020 and before March 1st, 2022. That is the SB 282 edition. Prior form motions provided by the court did not have that language, but that's a new edition, updated version of this form of this motion after passage of SB 282. I'll note though, under the statement of police and authority, it does not mention SB 282 or the language that was added by that bill. So in our office, sometimes I've seen people who, if the grounds for the expungement arises under SB 282, they've opted to draft their own pleadings instead of using the court form. Although I don't know that there's been any difference in outcome with or without the language of that, the very accurate points in authority language. And our next slide here is regarding the House Bill 2001 that passed just last Wednesday that provides for the automatic expungement of certain types of evictions. Section 65 of this very long bill provides that on an annual basis, each justice and circuit court shall enter an order setting aside a judgment and sealing the official records if the judgment in the case fits one of these criteria. First is the judgment has to either contain no money award, or the money award has expired or has been satisfied or discharged. So basically no other money disputes out there about this judgment. And the second, the judgment has to be one of two types. They must be at least 5 years old and is a judgment of restitution. So tenant has lost at least 5 years ago and paid up all the money. Or two, is a judgment by stipulation that is at least 12 months old. So one where there's been agreement reached, and in the at least last 12 months, the tenant or the landlord has not said the tenant has failed to comply with this the stipulated agreement for any reason. So then now the judgment is one that is eligible for expungement if there's no other money entangled in it. And I just want to note one other thing I forgot to mention earlier. This Section 65 here refers to justice court and circuit courts. As you, many of you would know, in OECI, when we look up records, we're only seeing records from the circuit courts and not justice courts. But in Oregon, for example, in Clackamas County, there are circuit courts where FED eviction cases are heard. So for us, if you're working with a client and you may not know whether or not they have a record that might be eligible for expungement, or if that's something that has been a barrier to housing for them, that is something I think the best way is just to point blank. Well, first is you can search them up. Second, depending on whether where they have lived, and if you know whether there's a justice court there, where there might be eviction records that we don't know about, explore the information with them. And then third is asking, have you experienced any denials of admission or any other housing barriers, to kind of explore and search, find out, dig, investigate into whether or not there might be any records out there that is causing them to be denied housing. Okay. Then
Diane,
just
quickly,
yes.
Related to this, we have a question in the chat. The form requires tenant applicant to know the date of the eviction judgment. What if the client we're assisting does not know that date? How can we help them find it?
That is, I think usually with OECI, we can find out the date that was entered or when the eviction judgment was entered. And then I think with the, like I was mentioning, if there are records in justice court where that's not available, I think it's it can call the court to see if they can pull that information for you.
Sorry, this is Katie. I did ask the question of what is OECI? Pardon the lack of familiarity with all of the acronyms, but you've used a couple that I'm not totally familiar with. Thank you.
Thank you for asking. I definitely assumed familiarity that, but some other folks refer to OGIN, but essentially that's the state court e-filing. Or I'm sorry, not e-filing, but the state court records system.
And I think it stands for Oregon E-Court Information System.
Great, thank you.
Thank you, Shelby. I also see a question here. If the landlord objects, how quickly is a hearing scheduled? And this is where I admit that none of the eviction expungement motions that I have filed have been objected to. I think it's partly so I don't know the answer to this necessarily. And partly it's because for us at least at the Portland Regional Office of Legal Aid, expungement is not sort of a standalone service, but more often is provided as a wraparound service. So if I had represented a tenant in an eviction case, and let's say we reached a stipulated agreement that provides that the tenant needs to move out by a certain date. If the tenant is able to move out by that date and there are no other requirements, so they're satisfied the only criteria, they've complied with the only terms of that agreement, and there's no money owed or anything, that record becomes immediately eligible for expungement. And I would, as sort of wraparound service for that case, help to fill out these paperwork for them. And in those cases, we're certain that, well, I guess a landlord could still act egregiously and object to it, but I have not yet had that happen. So we're mostly in cases where it's basically, we know that it is for sure eligible, and I have not had a case with an objection. I think the other thing I will note with these questions about the court and maybe like how quickly things are scheduled is, at least so the law passed in 2019 and took effect in 2020, and then very quickly, as folks know, in 2020 we started in the COVID-19 time period where folks are working from home, a lot of court processes and a lot of things are scrambling around. I don't know if it's a coincidence or not, you know, between COVID-19 and a lot of these new court sort of procedures, as well as court implementation of this new law. But sometimes I think, at least earlier on when I was filing some of these expungement paperwork in Multnomah County, it did take sometimes reaching out and prodding at the clerks to just check that it's, because I don't know really how it's been docketed and how they're tracking the passage of the time, so that you know, if there's no objection in 30 days has passed, that they will automatically expunge it. So I have had to earlier on reach out, you know, probably I'd set a tickler around like 45 days, and I reach out to them if I have not heard from them beforehand. So that's been sort of one oddity for counties where they probably deal with even fewer eviction cases and expungements. That might be, I guess I'm just flagging it as an issue that might come up for folks if you're filing it in counties that don't work with this a lot. They might not yet have a system because all else considered, it is sort of a little newer law. I think another issue I've had is it gets erased and I get no notification of it. So in some cases, there is the judgment entered or order entered setting aside the judgment, and I get a service copy of that. But there has also been times where I set a tickler where every week I'm just going in to sort of check, and then suddenly the record is gone. But weeks pass by, I still get no official notice of it. But I mean, if we can't find it, I guess that's good enough for me. And nor did my client in the case get notice of it. And then the other thing.
So
yes.
Quick follow-up question to that. Are some counties setting an automatic hearing date? I know with criminal record expungement, certain counties like Clackamas will automatically set a hearing date for the period beyond which the DA's office can object. Do you know if any courts are doing that for the period beyond which the landlord can object? Or is that, I don't know if you know anything about that sort of practice by any of the courts?
Unfortunately, I do not. Yeah, I don't know. Okay. So jumping from the questions back to where we are in the slides, this is the last two bullet points here. In addition to in House Bill 2001, providing for certain types of evictions records to be eligible for automatic expungement, this provides that specifically judgments that were entered on or before January 1st, 2014, they're not eligible for this automatic expungement, or this law does not apply to those judgments. And then the next one explains sort of when we can expect this law to take effect, you know, on or before December 31st of 2024. The courts need to be reviewing and entering its first order by that time. So I guess another way to put it is the latest we can expect that first order of automatic expungement happens December 31st, 2024. I mean, I guess the language provides that they can do it earlier too, but I don't know that realistically we expect them to be ahead of the game. Next slide is where you can find more resources that covers and expands on what I covered in the prior slides. The first link there is the Oregon Renters' Rights website that is maintained by our office, where we have a lot of just self-help guides and also guides that could be helpful for advocates of tenants, covering a range of common landlord-tenant issues. And then if you go to that link and you see that screenshot on the right, there is the one you want to click on in order to access the handbook that we have to cover this topic, and also link to the PDF there. And then the second one is the second link there is a one-pager. I believe, well, it's a one-pager explanation and then 2 pages of the form motion. But I'll note with those resources that they don't include, first is they don't include the HB 2001 information that we just covered in the prior slide. And second is that first link there does not include information about SB 282, which again was that addition of that additional ground allowing for the expungement of records or evictions that arose during the emergency COVID-19 time period.
Diane, we have another question in the chat. Do we know why HB 2001 excludes older pre-2014 judgments from automatic expungement? It seems like those would be exactly the types of judgments one would want expunged since they are stale and may not reflect the tenant's current ability to pay, etc.
That is a great question that unfortunately I have wondered and don't know the answer to, but I can look into that because I'm also curious about that. But if so, not answering that question directly, but like tangentially, as I had mentioned, records that are older than 5 years and their judgments of restitution shouldn't be considered by a landlord. So if you are working with someone who the record may not be well, now think about it. If they're eligible for expungement, is most or all cases, they shouldn't be one that a landlord can consider. Oh, this in short, I don't know the answer to why they're limited to the 2014 judgments.
And I will just note that we're happy to look into these questions where we don't have the answers to them, and I'll send a follow-up email when we do get the answers to these questions.
I wish instead the question was maybe why the provisions of SB 282 sunsets in 2018. 2028, that is. I might have a guess at that one, but that's neither here nor there.
Well, if you'd like to say, I think we're all ears.
Well, I think it's the time period, right? Because we're either within the 5 years after a record becomes eligible for expungement if it's at least 5 years old. And if, or under that SB 282, it arose between April 2020 and before March of 2022. So essentially, once that term expires, the SB 282, once that sunsets, then that same record is going to be eligible for expungement under one of the preceding grounds. So I think that the reversion of that, the Oregon eviction expungement law at that time just makes sure that the records would be similarly eligible for expungement.
And then the question in the chat, or question and comment, eligibility for SB 282 expungement is based solely on that date, correct? No other evidence is necessary.
It is the other requirement is that the tenant has paid any money owed. So if they owe no money, then yes, if this claim arose between that timeline during those dates, then that's sufficient. But if there's any money owed and landlord disputes that or something, there might be a hearing on that matter. And I guess about whether or not a judgment money or a money award has been satisfied, sometimes creditors are not, especially if we're talking about, what often gets called the mom and pop or the less sophisticated landlords or something. If they've got a money or a judgment with a money award, I don't know how often folks might be filing or notifying the court of satisfaction of the money award. So even though HB 2001 has that language that requires the justice and circuit courts to go through their records and automatically expunge some of those records, if in the record, for example, there's not a filing of a satisfaction of a full satisfaction of a money award, and even though it may be factually it happened, that wouldn't be a record that the court would automatically erase on its own.
So if that record is not there, like a satisfaction of money award in the court system, when folks are working with clients, would you recommend that they contact the landlord about, say the tenant is saying that they did comply and pay the money award? Should the tenants or the clients be contacting the landlord about that and asking them to file a satisfaction form? How I don't know if you have a recommendation about that.
I think my instinct might be to attach those as exhibits or attach a declaration to the motion with the tenant, showing that I have paid this amount of money and include that in the materials that get served on the landlord, as opposed to trying to get a landlord, particularly like a former landlord who really has no existing obligations to you. I mean, there are, landlords, current landlords who have a landlord obligation to tenants, and we find, it hard to get them to take action. So I think maybe for the tenant to do it themselves, as opposed to waiting on or relying on the landlord to provide the necessary proof, I guess, of their eligibility. That might be the way that I go about it instead. Hope that answers that question.
Yeah, and then I think we had a question potentially from Sean. You still have a question?
Yeah, just excuse me. Thanks for answering my question in the chat about the SB 282. Just a follow-up question to that. So then in the form, under the judgment, where it says the judgment I asked to set aside was a judgment of, you would check restitution in plaintiff's favor and then check the top box under that and then the third box, right?
So
The top box is I've satisfied the money award, and then the third box is the time eligibility.
Correct.
Okay, thank you.
Yes,
That's
yes,
it.
that is correct. Thank you. Oh, yes, Ashley, thank you, Sean, for taking us back to this form. Because one other thing I wanted to mention is when you access this form through either the links provided here, the court actually provides automatically a form objection for the landlord. That I think, if you look at a certificate of mailing, also it mentions it, right? I certified on the date I had mailed, I placed a true and complete copy of both this motion and a blank objection to the sent to the landlord, which would be the plaintiff in the FED case. But there's no statutory requirement that that blank objection form be provided to a landlord. So I think that's one other reason why, in addition to what I had mentioned earlier about this form under the statement of points and authorities, not including specifically the grounds provided by SB 282, why sometimes in our office I've seen folks draft their own pleadings and then not include the mailing of the objection form to the landlord, as this sort of like, if they're not inclined to, I'm not going to invite them to object to this expungement. So I just wanted to flag that it is included in the court's materials, but is not required by statute to be sent and mailed to the landlord.
Any other questions from folks? Seems like we're kind of, oh, go ahead, Katie.
This is Katie. I'm here with some other folks at Warwick. So we were just wondering about next steps. Like, is the idea that you'll actually have a clinic, like a date that you announce, and sort of like we all sit at a table and anybody who comes, we'll help you and we'll fill out your forms and, something like that? Or is it more sort of a virtual clinic that's like, we're just going to be on a list, and if folks come to y'all, then you would contact us and say, can you help this person?
So a little bit of both. We have an upcoming clinic, in-person clinic in Clackamas County that we already have scheduled for April 28th, and then another one for June 30th. Those are held at the Clackamas County Law Library. And so I think we are actually full of volunteers for the April date, but we have the June date that's in person. And that's for both criminal record expungement and eviction expungement. And so, that would be kind of the traditional clinic model. And then otherwise, yes, it's more of a virtual model. It's kind of how we've been functioning during the pandemic, where, clients call in, letting us know that they have, this need for either criminal record expungement or eviction expungement. And then we have a list of attorneys that have signed up for these clinics. And I usually send out kind of a blanket email saying, I have these many clients, needing, expungement for XYZ. And then you email back and let me know whether you're able to take the case or not. Then I give you the name so that you can run a conflict check. And then once the conflict check is completed and it's clear, then I send you the client file.
Hey, Shelby, it's Townsend Hyatt at
Yep.
Oric. The clinic on the 30th, June 30th, how exactly does that work? Is it for you have attorneys staff it from, say, a couple of hours during the day? Is it a evening thing? Because that might be easier for people who are working to come in and seek help. And just kind of, can you tell us a little bit more about how that part works?
Yeah, so typically they've been from 9 a.m. to noon. The Clackamas Law Library, I believe, closes at 5 p.m. So we haven't been able to do an evening clinic. I can talk with them to see if there's an option to do that. But we do that clinic in partnership with the Law Library and the Clackamas County Bar Association. So that's a great question. And, I think it's well taken that it, is easier for working people to make it after hours. So I'm actually going to look into that. But traditionally, those clinics are scheduled or have been scheduled from 9 to noon.
Okay. Thank you.
And how do we sign up? I know it sounds like April's already full. If we wanted to come in June, how do we?
Yeah, if you want to just email me, I'm going to put my email address in the chat, although I think many of you already have that, but just email me to let me know you're interested. I will put you on the list as volunteers for that clinic. And then I will send out a reminder a week ahead of time that the clinic is happening, and you'll just confirm that you're still able to attend.
Great. And sorry, Oric has so many questions for you. We're excited and we're curious.
Bring it.
So for non-attorneys who want to help support this work, my understanding is that those in-person clinics, just because of size limitations, you've tended to only have barred attorneys there, but that through the virtual clinic, that's where other non-attorneys can help. Do I have that right?
Yeah, that's correct. Yeah, I mean, we have been doing the criminal record expungement, and volunteer attorneys have been doing that virtually, and often their support staff get involved and help with those cases. So absolutely. Any other questions? Or Diane, any final thoughts?
Nope, I am good.
Just thanks for hosting this. Really appreciate it, and really appreciate this opportunity to get involved and do some of this impactful kind of one-on-one work. So thank you.
Great. Well, thank you all for attending. I do want to mention that if you haven't had a chance to sign up yet for our pro bono, new pro bono resource for volunteers, our website, it's www.probonooregon.org. There you can you'll eventually be able to access this training once we get our CLE credit approved. We'll post this video along with the materials to the website. You can share that with other folks who may be interested in signing up to volunteer. Folks can sign up to volunteer with us through that website. And we also post other pro bono cases that you can check out and potentially volunteer for that may not necessarily be this, but might be something that you have some sort of expertise in or would like to help out with. So check that out. We have CLEs posted there for other legal issues. And, if you're interested in doing criminal record expungement too, we've got our two most recent trainings from 2022 posted up there. The law did change January 1st, 2022. So it covers kind of how the law changed and how expungements work here now. And then, you know, all of our other pro bono projects also have CLEs posted up there. So check it out. And thanks again, everyone, for attending this CLE today. It was great to have you.
Thank you.
Thanks. Take care.